Swayam Prabha. Digital India. Educated India.
Hello everyone, welcome to the 7th lecture of our course on law of copyright, patent, trademark and other IP. We are discussing copyright law. We will be devoting 2 more lectures, the present one and the next lecture on copyright, after which we will start with patents. There will be 5-6 lectures on patent, followed by a few lectures on trademark and other forms. Now, if you have followed whatever we have done so far, you understood what are the subject matter on which copyright subsists, then you saw what are the rights given, and then we discussed who will own those rights, who is the first owner of copyright. After that, we discussed the instances of infringement in section 51, primary and secondary. Once infringement is proved, then comes the stage of defenses. We referred to the list of defenses which are there in section 52. The defendant can take one of those defenses. That is what we discussed in the last class, the fair use exemption and other exemptions. I particularly emphasized on 52(1)(I) and 52(1)(ZB), the disability clause of Copyright Act. So, these are the exemptions. But now suppose no exemptions are allowed, no defenses are allowed and infringement is proved. Then in that case, what are the remedies available for the plaintiff? How the copyright is to be enforced? This is what we propose to discuss in the present session. This session is on enforcement of copyright, in which we will be talking about the remedies which are there for breach of copyright or violation of copyright. Now, starting with the remedies, you see there are 3 things which we have to discuss here. One is civil remedies, which is in the form of injunction, damages and accounts of profit. So, there are 3 remedies which we will be talking about: injunction, damages and accounts of profit. We will understand the meaning of these. The civil remedies is contained in sections 54 to 62. Then you have the chapter on offences, in which we will talk about imprisonment, fine, seizure, delivery of infringing copies. These are the consequences. We will talk about the offences. These are there mainly in sections 63 to 66. You also have some offences defined in section 67, 68, but those are not that important. So, we will mainly talk about the offences which are there in sections 63 to 66. So, after civil remedies and the chapter on offences, the third thing which I will discuss is what we called as administrative remedy for infringement. This is contained in section 53, and this provision bans importation of infringing copies. So, this is what we propose to discuss: civil remedies in 54 to 62, offences in 63 to 66 and banning importation of infringing copies, which is an administrative remedy which is contained in section 53. Now, starting with civil remedies, the first point to understand is which court has jurisdiction in relation to infringement cases. Under section 62 subsection 1, a court of district judge is the court of first instance where you can file the case of infringement. It is not to be filed in any court as per valuation. No, it has to be filed before the court of district judge. And when I am saying court of district judge, it includes all those high courts which have ordinary original jurisdiction. In India, you must be where there are 5 high courts which have ordinary original jurisdiction: Delhi, Calcutta, Bombay, Madras and Shimla High Court. These high courts have original jurisdiction where suits are filed as per valuation. So, for all other places, the court of district judge will have unlimited jurisdiction, pecuniary jurisdiction. For these places, the court of district judge will have an upper cap on territorial jurisdiction, beyond which, if the matter is of value more than that, it will be filed directly in the High Court: Calcutta, Delhi, Bombay, Madras and Shimla. The second important point is there in 62 subsection 2, which is about place of filing the suit. You must have read about place of suing in CPC. The place of suing in CPC you have read is the place where defendant lives. You will file a civil suit where the defendant lives, or where defendant works for gain, he has his office, or where the cause of action arises. But the place of suing principle has been reversed in intellectual property laws. In Copyright Act, section 62 subsection 2 says that the infringement suit will be filed at a place where plaintiff lives or works for gain. So, therefore, the place of suing principle has been reversed, keep in mind. So, section 62 subsection 1 tells me that court of district judge, including high court having original jurisdiction, shall be the court of first instance where you will file the case of infringement. Subsection 2 tells me that the place of suing has been reversed. Now, the place of suing is the place where the plaintiff lives and not the place where the defendant lives. The limitation period within which you must file the case is 3 years. Who can file a case? The owner of copyright, of course, can file a case. The assignee of copyright can file a case. Assignee of copyright, if you recall, I said assignment creates interest in favor of assignee. So, assignee is as good as the owner of the rights which have been assigned. So, assignee can file a case, owner can file a case, even exclusive licensee can also file a case. Exclusive license has been defined, we discussed it. We said exclusive license means a license granted to one individual excluding all others. Even the owner is excluded from exercising those rights, then such a license becomes exclusive license. An exclusive licensee can also file a case of infringement, and if he files a case of infringement, then generally owner will be made as one of the co-defendants. And if a case filed by an exclusive licensee is allowed, no fresh suit by the owner will be allowed in that case. So, therefore, these are the points one has to keep in mind in relation to filing of a suit of infringement. The court of first instance, the limitation period, the place of suing and who can file. Owner can file, assignee can file, exclusive licensee can also file, and generally the owner will be made one of the co-defendant. And once a suit of exclusive licensee is allowed, then owner will not be allowed to file a case. I said there are 3 civil remedies we will be talking about. One is injunction, the other is damages, and third is accounts of profit. Let us understand what is injunction. We have a definition here. Injunction is a judicial process by which one who is threatening to invade or has invaded the legal or equitable right of another is restrained from commencing such act or is commanded to restore. So, it is not that you can claim injunction when one is threatening to invade your right. It is preventive as well as curative. If I am threatening to invade your right, you can claim an injunction restraining me from invading your right. If I have invaded your right, you can claim an injunction requiring me to restore the original position. So, therefore, injunction will have both positive as well as the negative content. Injunction can be permanent injunction, it can be temporary injunction. There are certain forms of orders which are commonly used in intellectual property laws. One such order is called Anton Pillar order. In the year 1976, a case was decided called as Anton Pillar KG. Anton Pillar KG versus Manufacturing Processes Limited 1976. And in this case, an order was passed which later became popularly known as Anton Pillar order. Let us see what is this order. It was passed in a judgment called as Anton Pillar KG versus Manufacturing Processes Limited 1976. This is a case of England in which the judge says, in appropriate cases, we will see what are those cases which are appropriate for passing an Anton Pillar order. Court says, in appropriate cases, the court has inherent jurisdiction on an application by the plaintiff made ex parte. So, the order will be passed without inviting the defendant to contest. It will be an ex parte order. And in camera, that means the proceedings will be in camera proceedings. Outsiders will not be allowed to sit in the proceeding. So, in appropriate cases, an ex parte order may be passed against the defendant in a proceeding which is an in camera proceeding, by which the defendant may be required to permit the plaintiff to enter his premises. So, the court may require the defendant to permit the plaintiff and his solicitor to enter the premises of the defendant, take inspection of the relevant documents and articles, and take copies thereof, or even remove them for safe custody. So, what all is there in this paragraph? There will be an in-camera proceeding in which an ex parte order may be issued in favor of plaintiff against the defendant, provided the case is an appropriate case. By way of this order, defendant will be required to allow the plaintiff and his solicitor to enter his premises, inspect the documents, inspect the incriminating articles, can even take copies of those documents and samples of those incriminating articles, and the plaintiff may also be allowed to remove those incriminating things and documents to safe custody. That is the extent of Anton Pillar order. Keep in mind that the information obtained by executing Anton Pillar order can be used against other parties in other proceedings also. For example, I inspected the premises of the seller of infringing copy of phonogram, and during my inspection I discovered a register which contains the details of the supplier of those infringing copies. This information can be used in a proceeding against the supplier of those infringing copies. So, the information obtained by executing Anton Pillar order can be used against a third party in a different proceeding also. Can this order be passed in India? Can we get an Anton Pillar order in India? It is a decision passed in English court. Is it binding on us? No. Do we have something similar to it? In the case called as National Garments versus National Apparels 1990, National Garments versus National Apparels 1990, court said that a similar ex parte order can be passed in India also, subject to the condition that plaintiff may be allowed to inspect the premises of defendant, but he cannot be allowed to take copies and samples. He cannot be allowed to remove those incriminating things to safe custody. So, to that extent, Indian order will be different from Anton Pillar order. But what plaintiff can do here is, when he is allowed to inspect the premises of defendant, he can prepare an inventory and hand it over to the court. He can prepare an inventory of incriminating things and present it to court and claim a separate order for appointment of receiver, through which he will ensure safe custody of the incriminating articles. So, on that point, the Indian order will be different from the typical Anton Pillar order. But yes, an order similar to Anton Pillar order, an ex parte interlocutory order to inspect the premises of defendant, this can be passed, but the plaintiff can only be allowed to take the inventory of the offending articles and subsequently a separate order may be claimed by which the safety of the incriminating articles, offending articles may be ensured. I said Anton pillar order can be passed in appropriate cases. What are those appropriate cases? In Anton Pillar KG versus Manufacturing Processes Limited, court said the case is an appropriate case if it is extremely strong prima facie case. Second, the plaintiff must prove the damage, potential or actual, saying that the damage which may be caused is very serious. And third, there must be clear evidences. There must be clear evidences that the defendants have in their possession incriminating documents or things, and there is a real possibility that they may destroy such material, and therefore an order, ex parte order, is claimed. Anton pillar order is not kind of search warrant, it is an order in personam to the defendant to allow the plaintiff to visit the premises. And you must be aware that any equity based order must be, see, any ex parte order is what? An equity based order. You are compromising with the due process requirements. You are not allowing the defendant to come and defend his case. Such equity based orders must be passed with equity based safeguards. So the law says that if scope of Anton pillar order is abused by the plaintiff, it may amount to contempt. The law says if the content of Anton pillar order is disclosed to third parties, it may amount to contempt. So there are safeguards. But it also says that if defendant fails to honor the Anton pillar order, that would also amount to a contempt. My point is, any ex parte order must be passed with certain equity based safeguards. And in this case, the English court says that abuse of Anton pillar order would amount to contempt. In Indian context, such an ex parte order can be passed under Order 11 of CPC, which provides for inspection and discoveries. But there is a limitation, as I mentioned, you cannot take the samples, you can only prepare an inventory and hand it over to the court for any further orders. Another order which is quite often used is called as Mareva injunction. Mareva injunction is a particular form of injunction, the purpose of which is to restrain the defendant from disposing of the assets which may be required to satisfy the plaintiff's claim or removing them from the jurisdiction of the court. So you are asking the court to pass an order restraining the defendant from disposing of the assets or disposing of the incriminating or disputed subject matter. You are requesting the court to pass an order requiring the defendant to, restraining the defendant from removing those incriminating things from the jurisdiction of the court. Because tomorrow, if the plaintiff wins the case, there will be nothing to compensate him because the subject matter has been disposed of or has been removed from the jurisdiction of the court. So therefore, there will be nothing left for the plaintiff to get compensated. Therefore, in order to preserve the subject matter, a Mareva injunction may be claimed. It is again an ex parte order because there is a case called as CBS versus Lambert, 1983. In CBS versus Lambert, court says that surprise is very important in such orders. It is of no use to pass an order restraining the defendant to stop disposing of the assets unless the order is passed in an ex parte manner. The prevention of disposal is not of much use if the plaintiff cannot locate the assets. Therefore, injunctions are usually sought ex parte. It's a very important order by way of which the account of defendant may be freezed, the defendant may be restrained from disposing of the assets, the defendant may be restrained from disposing of the incriminating articles or removing those articles from the jurisdiction of the court. Anton pillar order kind of order can be passed in Order 11 of CPC. A Mareva injunction kind of order can be passed under Order 39 of CPC. Order 39 Rule 1 and Rule 2 provide for something similar to what we have discussed in Mariva injunction. You must be aware that Order 39, Rule 1, Rule 2 provide for certain conditions. The plaintiff will have to prove prima facie case, irreparable loss. If the order is not passed, the loss which is going to be caused to the plaintiff cannot be repaired. And third, balance of convenience. Balance of convenience means if the order is not passed, what is the inconvenience caused to the plaintiff? And if the order is passed, what will be the inconvenience caused to the defendant? You have to weigh these inconveniences. If the inconvenience caused to plaintiff outweighs the inconvenience caused to defendant, it's a good case to pass an order under Order 39, Rule 1 and 2. So these are some of the interlocutory orders which can be passed. These are kind of preventive remedies. Enten pillar, a similar order is Order 11 CPC. Mariva injunction, a similar order is Order 39, Rule 1 and 2 of CPC. In addition to injunction, you can also claim damages and accounts of profit. Article 45, Clause 1 of TRIPS agreement says, a copyright infringer must pay the copyright owner damages. Damages which are adequate to compensate for injury to the right holder. So damages are commensurate to the injury suffered by the right holder, or damages are commensurate to the depreciation in the value of copyright. What do we mean by depreciation in value of copyright? There is a film released and simultaneously the pirated version of that film is also available. But nobody is willing to watch that pirated version, meaning thereby the value of copyright has not decreased. Everybody is watching it in the theatre, or everybody is watching it by procuring lawful copy. So therefore, there is no depreciation in the value of copyright. So what is the situation? If damages are commensurate to depreciation, in this case where there is no depreciation, there will be nominal damages, right? There will be nominal damages. And if you recall, while discussing infringement, primary infringement, I said that primary infringement is based on the principle of strict liability. If it is based on principle of strict liability, means absence of intention to commit infringement, absence of knowledge is not a good defense. However, in case of unintentional infringement, damages may not be paid. Court may not grant damages or may grant very nominal damages in case where the infringement is unintentional. But if there is an infringement, some damage is presumed. As I said, damages represent the loss. Damages are commensurate to the loss suffered by the plaintiff. Damages are commensurate to the depreciation in the value of copyright. On the other hand, accounts of profit is equal to the profit earned by the defendant. Now, one can easily understand that by and large the profit earned by the defendant will be equal to the loss suffered by the plaintiff. Although my act nowhere says that these two cannot be obtained together, the act nowhere says that damages and account of profit cannot be claimed together, but still it is not logical to allow both the remedies, because damages and account of profit will by and large be the same. So you don't get the double of money. So you either claim damages or accounts of profit. And one has to be very clear that damages can be calculated on the basis of information and documents which are in possession of the plaintiff, whereas account of profit is to be calculated on the basis of documents which are in the custody of defendant, the account books which are in the custody of defendant. It may be difficult for us to get access to those account books. Those account books may be disposed of. So therefore, it is wise to go for damages, because you can assess the loss on the basis of the documents and information available in your custody. The general principle of contract will apply for special damages. You will claim special damages. Special loss will lead to special damages. General loss will lead to general damages. For flagrancy of infringement, excessive damages can be claimed. So, what all we have understood? We understood the damages in the form of injunction, can be permanent injunction, can be interlocutory injunction in the form of ante pillar, in the form of mareva, under 11 of CPC, order 39 of CPC. You can claim damages, you can claim accounts of profit, you cannot claim both of these. These are the civil remedies for violation of copyright. Now, the next chapter is offences. Many books will say that these are criminal remedies for violation of copyright, but that is not correct. These are not criminal remedies. The name itself is not right, criminal remedies. And second, we are not talking about infringement here. We are talking about offences. Offences have been defined in section 63, but there are few preliminary observations. Keep in mind that civil proceeding and criminal proceeding are distinct proceedings. These are independent of each other. Two can be availed simultaneously. Pendency of civil suit will not mean that criminal proceeding will be stayed. So, there is no justification for staying criminal proceeding on the ground that a civil suit is pending. No. Same question of law may be involved, but one is civil in nature, the other is criminal in nature. Both can be simultaneously obtained. Now, let us see what are the offences which have been defined in this Act. Section 63 defines an offence which says that any person who knowingly infringes copyright or any other right conferred by this Act. Any person who knowingly infringes or abates in infringement of copyright or any other right conferred by this Act is committing an offence in section 63, which shall be punishable with imprisonment for a term which shall not be less than 6 months, but which may extend to 3 years, and with fine which shall not be less than 50,000, but which may extend to 2 lakh rupees. So, punishment is prescribed, maximum punishment, maximum imprisonment 3 years, maximum fine 2 lakh rupees. We will try to understand the nature of this offence. But what is the offence defined here is, whoever knowingly infringes or abates in infringement of copyright or any other right conferred by this Act. What other rights conferred by this Act may be considered here? We will discuss section 37 of the Act talks about rights of broadcasters. We will discuss section 38 of the Act provides for rights of performers. So, any other right conferred by this Act will include broadcasters' rights and performers' rights. That is why I am saying it is not just infringement of copyright. It also includes abatement to commit infringement. So, it is more than what you have in section 51. So, we cannot say that 63 talks about criminal remedies. It is a distinct provision which defines an offence. So, whoever knowingly infringes is committing an offence of 63 as well as infringement of 51. But whoever is committing infringement without knowledge is only committing infringement, he is not committing an offence. Mens rea is an important element in section 63. Therefore, kindly distinguish 51 from 63. 51 is infringement, 63 is offences, and I gave you one example. If I am committing infringement, knowing that I am committing infringement, then I am infringing as well as committing offence. But if it is a case of innocent infringement, it is definitely infringement because that is based on strict liability principle, but it is not an offence. So, that is the reason why I am saying that it is wrong to call it criminal remedy. 63 is a distinct provision. It also talks about infringement of broadcasters' rights, infringement of performers' rights. Knowingly infringing broadcasters' right will also be an offence. Knowingly infringing performers' rights will also be an offence. As I said, mens rea is an important element as it happens in other crimes which you must have studied. In the previous slide, I specifically mentioned about the punishments. Maximum punishment, maximum imprisonment is 3 years and maximum fine is 2 lakh rupees. Now, if you look into your CRPC, part 2 of the first schedule of the CRPC, it says offences punishable with imprisonment for less than 3 years or with fine only. So, if the punishment is less than 3 years, then the offences are non-cognizable and bailable. If the offences are punishable for imprisonment for 3 years and more, then the offences may be called as cognizable and non-bailable. So, this is the classification. If it is less than 3 years, it is non-cognizable, bailable. If it is 3 or more, it is cognizable, non-bailable. That is the classification. Now, going by this classification, when one can come to the conclusion that the maximum imprisonment is 3 years, in most of the cases it is going to be less than 3 years. So, therefore, what is the nature of offence here? It should be called as non-cognizable, bailable. And there are many judgments. For example, Supreme Court in its judgment called as Avinash Bhosle versus Union of India considered the nature to be non-cognizable and bailable, because in most of the cases the punishment will be less than 3 years. But recently in 2022, the case called as Messrs. NITPRO International versus the State of NCT of Delhi and another, this case was decided. It's a very small order of 6-7 pages in which Supreme Court says that offence under section 63 is a cognizable offence, it's a non-bailable offence. And this was held on the ground that if the punishment is 3 years or more, it should be cognizable. Now, therefore, now the situation is police can make arrest without warrant, whereas this does not seem to be in line with what the Supreme Court has held in the case of Avinash Bhosle versus Union of India, in which it was considered as non-cognizable and bailable. And there are judgments of various high courts in which various high courts have also held the offence to be of non-cognizable nature, bailable nature. And there is a lot of criticism of this judgment of Messrs. NITPRO International. There are people who are writing against the judgment, saying that this appears to be a bit harsh, because in most of the cases the punishment will definitely be less than 3 years. So, we have understood section 63. Whoever knowingly infringes or abates an infringement of copyright or any other right conferred by this act is committing an offence punishable by a maximum imprisonment of 3 years. But now, let us be sure, let us be clear that according to Supreme Court, the nature of the offence is cognizable, non-bailable. From 1963, in the year 1984, almost all the provisions of this chapter offences in which punishments have been prescribed, in all these provisions, the punishments were enhanced in the year 1984 by amendment. This was the time when record piracy and videotape piracy was rampant, and in order to curb the rampant privacy prevalent during that time, the punishments prescribed in sections 63 to 70 were enhanced. There is an interesting provision in section 63B. This talks about knowingly making use of a infringing copy of computer program. Whoever knowingly uses an infringing copy of computer program is committing an offence in section 63B. And the punishment prescribed is minimum 7 days to 3 years. Now, this is interesting to note, minimum punishment is just 7 days, whereas in section 63 minimum punishment is 6 months. Why this reduced imprisonment? You have to think about it. Most of the people are using infringing copy of computer programs on their computers. Large number of people are using. For them, it is an offence punishable with 7 days or to a maximum of 3 years, and fine which shall be 50,000 to 1 lakh. You see again the higher punishment, higher fine is less here. In section 63 we said it is 2 lakhs. There is one more exception here. If the computer program is not used for gain, if it is not used in the course of trade, the punishment will be reduced. So, a lot of space has been created in section 63B in relation to this offence where somebody is knowingly using infringing copy of a computer program on his computer. 63 is a general offence. 63B is an offence specific to use of computer program, infringing copy of computer program. Section 64 talks about power of police officer of rank not less than sub-inspector. Power of police officer of rank not less than sub-inspector to seize infringing copies. There were allegations that section 64 is an arbitrary provision because it does not provide guideline as to what are the guidelines for exercise of power by the officer. But courts have held that by the fact that the power has been given to a senior officer of the rank of sub-inspector, it is not likely to be misused, and therefore it is a valid provision. There is a case of Delhi High Court, Event and Entertainment Management Association versus Union of India, in which Delhi High Court has provided an important safeguard. Delhi High Court says that while seizing goods, if the sub-inspector comes to my house to seize infringing copy of the goods, when he has to take an action, I can take the plea of section 52. Mind, section 52 gives me defenses. I can argue that I have made this copy in the course of imparting instruction. I am a teacher. I will be using this book for my lectures. So, I have made copies in the course of imparting instruction. What will happen if I take this defense? What should the police officer do when I take this defense? The Delhi High Court says that the police officer ought to satisfy himself that the defense taken by me is tenable, is acceptable or not. It is only when the defense is not tenable, it is not acceptable, that the sub-inspector can seize those copies. It is a very important safeguard. But it is important to note that this safeguard is missing with respect to section 63. In relation to section 64, court says that the safeguard is important. Why? Because seizure in this can be effected without a warrant and without immediate cognizance by a magistrate. Now, the situation is when a copy has to be seized without warrant, there are safeguards. In section 63, after the recent Supreme Court judgment, an infringer or a so-called infringer is going to be arrested without warrant. Should we not have a similar safeguard in section 63 also? That is a question for you to make an opinion, to decide. So, section 64 provides a situation where a police officer of rank not less than sub-inspector will seize the infringing copies wherever found, and when he goes to seize those infringing copies, the person there may take the defense of 52, and it is the responsibility of the police officer to decide whether the defense is tenable or not, and it is only when it is not tenable that the police officer may go ahead and seize the goods. In addition to the offences which I mentioned, which are there in section 63, section 64, we have two new provisions which came in 2012 amendment. One is section 65A, the other is section 65B. And these are based on WIPO internet treaties. Section 65A is based on articles 11 of WCT and 18 of WPPT. And section 65B is based on articles 12 of WCT and 19 of WPPT. What these articles of WIPO internet treaties provide for? The WIPO internet treaties of 1996, WCT and WPPT have a digital agenda. I mentioned about this digital agenda in my first lecture. There are 3 points in that digital agenda. Point number 1, the communication right is expanded. How? Now the content creators, the owners of work, performance, phonogram, they are allowed to use internet as a mode of communication. Because in the absence of this right, if my work is communicated through internet, I cannot stop somebody from doing it. I can stop you from doing something if I am the exclusive right holder. So first thing is, let us expand communication right. And how do we do that? By modifying the definition of communication in section 2FF. Section 2FF defines communication. Communication means any kind of communication, direct communication, communication by display, communication which may be called as diffused communication, broadcasting. Now you will understand that in case of diffused communication, there can be two things included. One is where the broadcaster decides what is the time when this program is to be diffused, is to be shown. What are the places where this program is to be shown? So when the time and place is decided by the broadcaster, it is typical broadcasting. But when time and place is chosen individually by me, by the user, that can be a case of webcasting. There is some series on some OTT channel. I want to watch that series. I will get access to internet at any place where I am. At whatever time I want to watch that OTT series, I can watch it. So in the definition 2FF, the definition says that even where the place and time is chosen individually, such a communication is within the definition of communication. That includes webcasting or communication through internet within the definition of communication. So first limb of WIPO digital agenda, that is expansion of communication right, is very much done in Indian law by amending the definition of 2FF in the year 2012. Communication through internet is also included in the definition of communication. And now I have this additional mode of communicating my work, my performance, my phonogram. The second limb is WIPO internet treaties will say that when you are communicating using internet, then it is your responsibility to protect your work by employing effective technological measures. If I am protecting my work, my performance myself, what will the law do? Law will punish those who try to circumvent that effective technological measure. We have included it in our law in section 65A. 65A is protection for effective technological measures. It says that if the owner of right conferred by this act, what are the rights conferred by this act? Copyright, performer's rights, broadcaster's right. If the owner of right conferred by this act protects his rights by employing effective technological measure, then that technology must be protected. There is an important point here. WCT is about works. WPPT is about performance and phonogram. Both these treaties did not talk about broadcast. But my provision, by the fact that it talks about any right conferred by this act, will also include broadcasters' rights. So my section 65 is more extensive as compared to WIPO treaties, in the sense that it also includes protection of technology for broadcasters' rights. So if I have employed an effective technology, if I have employed technological measures to protect my work, my performance, my phonogram, my broadcast, then law will punish those who try to circumvent the technology with the intention to commit infringement. So if there is a person who wants to commit infringement and for that purpose in mind he circumvents the technology, it amounts to an offence punishable under section 65A. The punishment may extend to 2 years. The offender may also be liable to fine. So therefore, the second limb of WIPO digital agenda, that when you are using internet as a mode of communication, employ effective technological measure to protect your work, etc. And law will punish those who try to circumvent the technological measures, that has been included in section 65A. Yes, it is slightly broader as compared to WIPO provisions. There are 2 points which we need to understand here. As I have been saying, that law says that you will have to protect your work, etc. by employing effective technological measures. Law will punish those who try to circumvent the technology, but law will punish only when your technology is an effective technology. At one point of time, we used to think that symmetric cryptography is an effective technology, which is no more an effective technology. Asymmetric cryptography today becomes a secure technology. So obligation on me is to protect my work, etc. by employing a technological measure which is effective. Only then law will protect it. Only then law will punish the person who is circumventing. But how will you decide whether the technology is effective or not? In America, they have a law called as Digital Millennium Copyright Act, says a technology is effective if it ensures access control and use control. Access control means unless you fulfill the conditions, you cannot have access to my work. There are many online databases nowadays. You will have to subscribe to those databases as an institution, only then the students can access those databases. Access is controlled. And how do they control the access? By way of employing technological measures which are effective, which cannot be circumvented. The second point is use control. When you enter into those databases, you will realize that you are in a position to download some articles. Some articles can only be read. You can copy from some articles in relation to some other articles. You cannot copy and paste. So therefore, there is use control. What are the permitted users will be determined by the owner himself. So any technology which ensures access control or use control is an effective technology. And what do we mean by circumvention? Any act which neutralizes access control and use control mechanism employed by the owner is circumvention. We must not define a technical term in technical terms. Circumvention can be done by cracking or by neutralizing or by hacking, or let's not define circumvention with the help of these terms. Circumvention means any act which neutralizes the features of access control and use control of that technology. This is what you have in section 65A subsection 1. Now section 65A2. Section 65A2 provides certain exceptions to subsection 1, and there are many clauses. Clause A is particularly important. It says that nothing contained in subsection 1 shall prevent anyone from circumventing the technology for any purposes which are not prohibited under the Act. Now, you see all the purposes which we have in section 52, permitted uses, all the purposes mentioned in section 52 are permitted purposes. And for those purposes, if you are circumventing some technology, you are exempted from liability here. So, first exemption is anybody who is circumventing for any purpose which is not prohibited under this Act is not committing an offence. There is a proviso which says that any person who is allowing the circumventer the access to the work, that third person must maintain a record of the person who was allowed to circumvent, right. So, this is a very useful exception. Then there are other clauses which provide exception when circumvention is done for research purposes, to understand the working of the phenomena of encryption. If the circumvention is done to examine the security system effectiveness of security of my computer network, exempted from liability. If circumvention is done by security agencies for surveillance, for security purposes, then there is an exemption. So, you have list of exceptions to the general provision which is contained in section 65A1. But the most important thing is the first clause which says that you are allowed to circumvent any technology so as to get access to the work if you are getting access to the work for a purpose which is not prohibited in this Act. So, if I want to convert your work, your book into Braille, which is allowed if you remember in section 52(1)(ZB), if I want to convert your book into Braille, I can break the technology, get access to your work, convert it into Braille. I am not committing an offence under section 65A. So, that is what you have in section 65A. This was based on the second aspect of digital agenda. First is expansion of communication right. Second is you protect your work yourself by employing effective technological measure. Third is when you are using internet as a mode of communication. When you are using internet as a mode of communication, there are some information which you must provide. Those information are required for efficient management of rights in online medium. These informations are called as rights management information. These are required for efficient management of rights. Section 2(xa) defines the term rights management information. Name of the author, name of the owner, residence of the author and owner. These are some basic informations which are required, because you also appreciate that in online medium, the biggest challenge is anonymity. To face that challenge, law requires anybody who is using internet as a mode of communication to provide certain information which are required for efficient management of rights. What are the terms and conditions on which you are going to allow use of your work? All these are rights management information. Now, what will law do? Law will punish those who tinker with this rights management information. See what your provision says. Section 65 says, any person who knowingly removes or alters any rights management information without authority. I have used internet as a mode of communication. I have protected my work by technological measures. I have provided rights management information, and anyone who knowingly tinkers with those rights management information is committing an offence under section 65B. Or anyone who deals with copies of the work, performance, etc., knowing that the rights management information in relation to these works, performance, etc., have been altered with, will be punished under section 65A. The punishment shall extend to 2 years, and he shall also be liable to fine. So, the third limb of WIPO digital agenda is included in section 65B of the Act. This is based on articles 12 of WCT and 19 of WPPT. It says whoever knowingly alters any rights management information or distributes, imports, deals in any copies of the work knowing that the rights management information has been altered with is punishable under this provision. There are some problems in this provision. I will request you to read the provision to understand the problems associated with it. Section 65 talks about works and performances alone. It does not refer to broadcast, whereas 65A refers to broadcast also. The proviso of section 65 says that you can also claim civil remedies in case of an offence committed here. Now, how can you claim civil remedies unless a civil wrong is defined? Further, section 65B only says whoever knowingly alters the rights management information. It does not say as to what is the kind of knowledge do we require. Is it the knowledge of act that I am doing it, or is it the knowledge of consequences that I by this act will lead to infringement? What is the kind of knowledge required in section 65 is not clear. Section 53 of the Act was amended in 2012. Now it says that if there is a person who apprehends, anticipates that there will be infringing copies of his work arriving into India, he may write a complaint to the Custom Commissioner, requesting the Custom Commissioner to declare those infringing copies to be prohibited goods. He has to mention the place where he is anticipating arrival of his infringing copies. He will have to mention the duration within which he is anticipating arrival of his infringing copies. That duration shall not exceed 12 months. The applicant will be asked to deposit security. The part of money will be used for storage purposes, demurrage purposes, and part of money may be used to compensate the importer if the complaint is proved to be wrong. Now, on the basis of this complaint, the custom authority may declare those infringing copies to be prohibited goods and will seize those infringing copies. Once those infringing copies are seized, the applicant fails to bring an order from a competent court regarding disposal of those infringing copies, then in that case, custom officer will release those infringing copies. So, what we discussed in this session is civil remedies, offences under section 63, 64, 65, 65A and B. 65A and 65B are new provisions which have come in 2012. We also refer to the administrative remedy of section 53. I'll ask you to go through these provisions. We will talk about some of the issues which are left so far, for example, collective administration, moral rights and neighbouring rights in the next session. I hope you have understood the remedies part clearly. Thank you very much for joining. See you in the next session. Thank you.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I am not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I am also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.